Last year I came out to speak and I told you about the horrors that you were about to face with the introduction of the new RCMP Act and regulations, and today I'm going to tell you about how some of those have materialized. But before we get to that, I'd just like to introduce the members of my team that are with me. Next to me is Sherry Scher, one of my associates, and next to Sherry is Carlin Modeste. So if you hear from one of us, we all work closely together as a team. They do a lot of the heavy lifting, and I do some of the court work and do a lot of the public speaking and engagement. Now, our primary fields of practice are labor, human rights, and administrative law. We're a virtual law firm, so what that means is we all work from home on a daily basis. But we do have an office. We've got arrangements with business centers, so anytime we need an office or a boardroom, we make those arrangements with the business center, and we can meet there. But we use web conferencing an awful lot, and we can show documents and have conferences that way. And as a result, we've been able to serve clients all across Canada. So in terms of our police clients, of course, we represent the Mounted Police Professional Association, Council of Record. We represent also the Port Moody Police Union, the Transit Police, as well a number of individual RCMP members who've retained us on their own. So that's a little bit about our firm and what we do. So the things I want to talk to you tonight, though, are primarily this: code of conduct investigations, how those are playing out under the new Act, talk about the new appeals procedure, talk about the revised grievance procedure, and then I'm going to touch on the class action lawsuit against the RCMP for unlawful disclosure of to a third party of members' confidential healthcare records. And then lastly, I'm going to touch on MPPAC's Legal Assistance Program, version 2.0. So starting with code of conduct investigations under the new RCMP Act and regulations, I'm going to give you 3 examples of how these are playing out of clients that we've currently represented. First code of conduct investigation involved a member who had filed a harassment complaint against a supervisor. And in the course of the harassment complaint and the grievance procedure, she'd made written submissions in support of her grievance. And as a result of those submissions, the supervisor commenced a code of conduct investigation against her, arguing that her submissions were harassment against him. And we wrote to them beforehand, gave them a demand letter saying, what you're doing is totally improper. There's an absolute defense here. She's got a claim to absolute privilege, and there's no cause of action against her at all. That didn't stop them at all. As a result, there was a finding that she had acted inappropriately and in a manner that was not in keeping with professional behavior expected by an RCMP member. And as a result, they imposed discipline, which consisted of counseling, and get this, special training. She had to take a respectful workplace course. So we didn't grieve it. We didn't appeal it. Instead, what we did was we filed an application for judicial review in federal court to quash it, arguing that she had an absolute defense based on absolute privilege. And the result was the discipline was rescinded, the member's employment record was cleared of all of the material, and the RCMP paid her costs. So that's one example of things that we've seen. The next code of conduct investigation, number 2, the member received a code of conduct mandate letter, which is how these things now start. An investigator from Professional Standards was assigned to conduct the investigation. The member was advised of her right to provide a voluntary statement during the code of conduct proceedings. But this is what she was advised in writing by the sergeant from Professional Standards. She was advised that any statement that you do make or answers that you give may be used against you or others under the Part 4 of the RCMP Act in any criminal, civil, or administrative proceeding, or for any other purpose. But that's contrary to what is included in the Act, because what the Act says in Section 40, Sub 3, is that no answer or statement made in response to a question described in Section 40, Sub 2 shall be used or receivable in any criminal or civil administrative action proceeding other than a proceeding under this part regarding an allegation that the member made a statement with the intent to deceive. We've written to the investigator, pointed out the law to him, but we have not yet received a response. Investigation number 3 is an interesting one. In this case, a member self-reports a potential breach of operational and tactical information to her spouse, soon to be ex-spouse. Before the code of conduct investigation begins, the member is interviewed by a polygraph examiner and gives a recorded statement. The member is then suspended with pay pending the commencement of a code of conduct investigation. The investigation begins and the member seeks legal advice. The RCMP agrees with us that the statement that was provided already by the polygraph examiner was not voluntary and was not properly obtained. So they agree not to use it for the purpose of the code of conduct investigation officially. So the RCMP then invites the member to submit to a second video recorded interview before a second polygraph examiner following interviews with her now ex-spouse and a former lover. So her former lover and her ex-spouse gave information that revealed that she disclosed tactical information to her spouse. The next thing I want to talk to you about is appeals, which is something that has arisen under the new Act. And here, members have a right to appeal a code of conduct or other measures, but they don't have a right to file a grievance. So the only avenue is to file an appeal. Appeals are only available for 14 days concerning final decisions with respect to the following matters, and there's a long list of them. Decisions by a conduct authority or a conduct board, temporary reassignments, suspensions, stoppages of pay or pay allowances, representation during a code of conduct process, revocation of appointment, discharge, demotion, discharge of a probationary member, relief from duty, and a requirement to submit to a medical examination or assessment, and investigation and resolution of a harassment complaint, and finally representation during the grievance or appeals process. Those are the only matters that can be subject to an appeal. The grievance process is also different than what you've been used to in the past as well. Only members directly or personally affected have the right to file a grievance. Similarly, if group grievances, let's say they said, okay, well, all plain clothes now, forget the plain clothes thing, we're not going to do that anymore, everyone has to wear a uniform. So it doesn't affect everybody, but it affects those people who used to wear plain clothes. That could be filed as a group grievance, not under this grievance procedure. It must be an act or omission committed by the RCMP. So that doesn't include things that the Treasury Board decides. And it doesn't include decisions that are made by the Privy Council. A member may not grieve a decision, act, or omission that can be resolved through another process set out in the Act or the regulations or under the Commissioner's standing orders. For example, a code of conduct, you have to use the appeal process. You can't grieve it. Classification process, can't grieve that, or reclassification. Other things, the Commissioner's standing orders now deal with things like harassment. So arguably you can't grieve harassment decisions. And we'll have to wait and see how far this is interpreted, but I can see it including things like filing a human rights complaint, right? You can't grieve anything that you could file a human rights complaint for. And then there's the new form, the 6439, that must be used to file the new grievances for. So if you use the wrong form, you get rejected on that basis. Now the time limits for a grievance is 30 days. And a couple of things you need to notice. It's a statutory time limit. So the idea behind that is you can't agree to extend it. So it's 30 days, come hell or high water. So you have to file a grievance within 30 days. In other organizations, like Port Moody or Transit Police, the union and the employer can agree to extend those time limits. Well, you don't have that option here of agreeing to extend it. It has to be done within 30 days. Now, the time limit from going from the first level to the second level is even shorter. It's 14 days. So those are some new things with the appeal process and the grievance process. So next I want to talk to you just a little bit about the class action lawsuit and tell you where we're at. So the notice of civil claim is filed in the BC Supreme Court under the BC Class Proceedings Act on the 9th of October. This relates to a 2014 decision by the Federal Privacy Commissioner that found that the RCMP had unlawfully disclosed certain RCMP members' confidential psychological counseling records. So the confidential information was disclosed. This is the kind of stuff that was disclosed. Member's name, their diagnosis, their symptoms and treatment details, and their employment history. The harm in the Dr. Webster case to the individual members, aside from losing Dr. Webster as the healthcare provider, is they handed the information up the line to various line managers, and we followed the train through all the way up to the commissioner. And the commissioner gave his blessing on this process to take place, and then passed the blessing all the way back down the line managers. So some of the vetted healthcare information went up the chain of command. So that's going to be the issue that is going to be argued in court. Now, in terms of where we're at, as of yesterday, all of the defendants except one, Dr. Fieschi, have now been served. She was out of the country, and they've are going to work on getting her consent to accept service on their behalf. If not, we've got some members that are willing to serve her. Interesting, the DOJ is defending on behalf, of course, the federal and provincial AGs, but as well, they've now indicated that with all of the defendants, with the exception of Fieschi, they're also defending them, which is out of the public purse. So we're going to make some hay with that. The DOJ has advised us that they don't intend to file a response to the notice of civil claim. So the next step in the process, given that advice once Fieschi is served, is we're going to apply for the appointment of a case management judge, and we're going to make our case to the case management judge that the respondents should be compelled to comply with the rules of court and file a response. So we'll make that argument there. And then the next step is to have the action certified as a class action. All right, any questions? Yes?
Sir, if I may, just a question back under the RCMP Act, the new Act. If a member is under a code of investigation, prior to the introduction of this new Act, can they use the new Act under that same code?
They shouldn't be able to, because again, it doesn't have retrospective effect, but we've heard from some quarters that that's what the RCMP is trying to do. Yeah. Any other questions? Okay, well, thank you very much.